Hi, everyone. Thank you so much for joining this discussion that we're hosting on India's newly released data protection rules. My name is Neha Chaudhary. I'm a partner with Ikigai Law, and I'm very proud and happy to introduce also my partner Sreenidhi, who leads our data governance practice. And over the next hour and a half, the way that we're thinking about doing this discussion is having a free flowing conversation across a whole bunch of issues that we are spotting, and I'm sure we'll keep spotting more issues as and when we're continuing to all take a closer look at the rules. We're hoping for this to be an interactive discussion. May I please request all of you to make excellent use of the chat box. Feel free to send us your questions. If you'd like to respond to anything that folks are raising in the chat box, feel free to do that as well. And just request that everyone, of course, be polite and respectful. And that's just sort of general housekeeping. And yeah, with that, I think we'll get started. Srinidhi, unless there was any other housekeeping note that I was supposed to share, which I've forgotten. But okay, awesome. So, on the rules, as we've been reading them, of course, we're reading them together with the Data Protection Act as well. As everyone knows, the Act was passed. It's been 16 months that we've been waiting for the data protection rules, and here they are. We understand from several interviews that the minister has done since the rules have been passed that we're looking at them being introduced or tabled before Parliament in the monsoon session. Before that, we've got a 45-day consultation period, and 18th February is the date by when comments are due to the IT ministry, to the government. After which I imagine they'll take these comments into account and uh, finalize the rules and table those before Parliament in the monsoon session. We also understand from the minister that we're looking at, once the law is fully enforced, we're looking at, I think, a 2-year horizon for compliance. Obviously, there will be some provisions that should come into effect in phases. So some will roll out on notification, and there will be a graded sort of timeline for compliance for a bunch of those other provisions as well. Now, I'm sure you've all been inundated with a flood of information and content around the Data Protection Act and the rules itself. So what we'll hopefully be doing in this conversation is keeping it super grounded, keeping it super practical, sharing insights where we're able to from the practical experiences and questions that we're seeing come up as we're taking clients through open questions as well as compliance related questions. Uh, what we're also hoping to cover is do this on two levels. One is because there is a policy window that's open and rules are open for consultation. What we'll do is we'll highlight some of these open questions or areas where it might be helpful to get a little bit more clarity from the government. So those of you who are considering submitting comments to the government, if this is something that you want to take into account, and if you find that it might be helpful, feel free to do that. And we'll also side by side be focusing on the compliance aspects. Now, when we've been reading the rules, the framing that we've been thinking about is perhaps a fourfold uh, categorization, right? The act and the rules. Number one, which perhaps in some ways is the most critical one. If you think about it from the perspective of the individual and is individual rights, the first one is, what does this mean from a business to consumer perspective, right? So, what are some of the obligations or what are some of the requirements that we've seen come out in the Data Protection Act and rules? And how is it that the individual interfaces with all of them? What is the implication that this has from a B2C perspective and for the individual? That is one. The second framing that we've been looking at is more of a business to business perspective. What does this mean for the relationships and the contracts that businesses have with a bunch of other businesses who will be a part of their network, whether it's data processors, whether it's vendors, whether it's anybody else, another data fiduciary with whom a business might be sharing this information? What does that ecosystem look like? A B2C framing as well as a B2B framing. The third way that we've been thinking about this is, what does this mean for the business or a company in-house, right? The bucket that we like to call get your house in order. What do I have to do internally? And this is where we say, where we imagine things like having security obligations, making sure that you have adequate security measures in place, or what you need to do in case of a breach. This is the bucket that we imagine looks at all of these things. And number four is the relationship of the business with the state, whether it's the data protection board or whether it's the government. We've all seen that there are potentially data localization requirements that are going to make a comeback. There are going to be instances in which the government can call for information. So there are a bunch of different ways in which the business will interact with the regulators or is expected to interact with the state as well. And that's the fourth bucket. For the purposes of this conversation, we'll be limiting ourselves to the first two buckets that I was talking about. What we see issues or open questions coming up in the B2C area as well as in the B2B area. So some of the things that we're hoping to cover will be notice, consent managers, data principal rights, data retention. How does an individual exercise any of the rights that she's entitled to? What is the difference between processors and controllers, and what kind of contractual obligations are we sort of looking at? I'll pause with that, and maybe Srinivasan, I'll turn to you to kick us off um, with notice straight up front. Couple of interesting things in there that we've also been, scratching our heads around, and in all of the commentary that we've been reading around the rules as well, a bunch of open questions coming up. There's this requirement for notice to perhaps be to include an itemized description, right? There is the requirement that you disclose all possible purposes to the individual. Is that realistic? Is that possible? How does that play out in practice? The Act also talks about notice being available in all official languages, 22 languages. So how is that going to play out really? Notices are supposed to be uh, you're supposed to be able to understand the notice independently of any other information, right? So what does that mean? Am I looking at creating separate notices? Am I looking at, is my privacy policy enough? Do I need to do something drastically different? uh, yeah, a bunch of open questions. So if that's something that you want to take up first.
Sure. Hi, Neha. Hi, everyone. Thanks very much for joining in. So on notice, Neha, I think you pointed out all of the things that the rules are adding now on top of the Act requirements. It uses terms like clear, understandable to the user. This has to be separate from any other information given to the user, like the terms of use, guidelines, any other content generally on the website of the platform. It has to give them a fair account so that they're able to give informed consent. There are some minimum details that are provided for in the rules, like an itemized description of the data, the purposes, the services. You have to provide them with details of a communication link that says how a user can exercise their rights, complain to the board, withdraw consent. So a couple of takeaways from there. I think this earlier approach, kind of this age-old approach of having everything in a detailed privacy policy with just a link when one is signing up to the terms and the privacy policy may not work anymore. I think this is something we've been considering and saying since the Act had come out, that just simply having a link alongside this privacy policy that one has to click and go to may not cut it anymore. The intention very much is that on the UI itself, there is some more information for the user, enough such that they can make some kind of a choice about what is it that they're really providing their information for. I think this does call for some smart design choices, perhaps layered notices, drop downs, perhaps even an intermediate screen. I completely understand. And whenever we've had this conversation with business and product folks, there is a lot of friction in the user journey that even adding one phrase, one term, it can spook the users as well. It may not be particularly helpful to users. So I think some smart design choices there. Could you give, say, highlights, or could it be a layered approach such that if I'm only a website user, it only means, I only need information regarding access to cookies. If I'm creating an account on the platform, or if I'm simply logging in, there is a separate bucket of purposes and data that is relevant to me. I think that's what it means when they say itemized description of the services to be provided. So you link the service or the activity with the data, provide enough information upfront on the UI itself, or if it is a different channel of communication through those modes. Yeah, like we were discussing, when it says minimum details, it's an itemized description of the data and the purposes and the services. So that very much means that one has to create an inventory of the data. This goes to our the third bucket that we'd identified, which was getting your house in order, having that inventory in place so that you're able to provide information to the individuals. I think that is something that at a minimum in any case companies have to do. And based on that, I mean, those inventories can run into many hundreds of pages as well, because there are different teams, there are different use cases, but you decide what is relevant in a particular context when this notice is being shown to the user. I think because it says a fair account, enough to give users information such that the consent is informed, there is some judgment call that the business has to take. And perhaps the rules also allow that flexibility, that you're best placed. It doesn't give a format, it doesn't give a template as such, because that could look very different for unique business needs.
Anticipating anything changing, uh, anything changing in this really, or are we just thinking that I feel like the government has made up its mind on what notice should look like? Is there anything that we think we might want some clarity on? Uh, you know, model notices or something? Will that be a good thing just to get? And how does this compare with notice provisions that we see perhaps in other parts of the world, right? I remember reading something online that said that we're not required to give details about other data fiduciaries to which data needs to be shared, right? Is that something that has been omitted for any specific reason, do you think? Or what is the impact of this likely to be in practice?
You're right that the some other privacy regimes in their privacy notices say you also have to at least tell the individual categories of recipients with whom data will be shared, if not individual lists of recipients, data retention practices, security practices, and so on. I think the rules haven't gone into that level of granular detail, but left it as a fair account. And besides the data and the purposes, you take a call as to what all is relevant. But at the same time, I will point out that under user rights, a user does have the option to ask the data fiduciary,
Sure.
who have you shared my information with? So that is anyway information that one must maintain. And I do think in privacy notices, privacy policies, at least, the website privacy policies will continue to have those sections where we describe to whom data is shared with. And I also, I think, just on who can you share it with, you can only share it with persons or third parties like your vendors or other data fiduciaries if it matches the purposes that you specified. So only if you're sharing data for those purposes can you share with third parties. So that purpose limitation is in any case
Built
built
in.
in here. And on
Right.
your question, that's an interesting one. I think it's a bit of a balance. On one hand, it will be great if there is some illustrative example or illustrations of how this might look. But at the same time, I wouldn't want to be overly prescriptive here. I think there is a reason for that flexibility to account for your unique UI needs, or if you're an app, if you're a website, if you're any different channel of communication with the individual, you do want to have some flexibility in how you're actually implementing the notice requirements. Yeah, I wonder if you have a thought, if there's anything additional in the which could actually benefit businesses or aid compliance.
No, I feel like I'm always biased towards non-prescriptive but helpful. Hey, this is a model format that you could follow or something like that. Where I start to get uncomfortable, and we see that coming up in a bunch of different places in the law, in the rules actually, and we've discussed this, you and I also before, is where I feel like I start to get uncomfortable where there is a hard prescription in terms of, this is what I want you to do, and this is also how I want you to do it. And I think that that's also been our experience, at least when we're helping businesses with compliance, that they're very happy for the obligation of the what to be there in the law, but always helpful if you're able to figure out the way to do it. So yeah, maybe some models, as long as those are not the only way in which you're expected to demonstrate compliance with the act. I feel like that might be helpful, right? And obviously now I want to switch to consent a little bit, because again, closely tied into the question of notice. You also spoke about perhaps pop-up, just in time notices and needing to take consent real time in some ways through changes to UI, and not just directing sort of to privacy policies. We're going to have a whole new ecosystem through consent managers in some way, shape, or form. What are we imagining this role? I mean, I saw Minister Vaishnav again had referred to the data empowerment and protection architecture. He had said that, perhaps that could be a template for how consent managers play out. We've seen this play out in the account aggregator ecosystem, perhaps. So we do have perhaps some guidance of some guidance for how this might play out. That's one. And I feel like the really tricky piece here is going to be verifiable parental consent for when it comes to processing children's data, right? And this is something that we were hoping that the rules would give us a lot more clarity on when the obligation was there, when the obligation was first introduced into the act. And they've outlined two measures. They've said, where you have, if you're a parent, if the data of the parent is already available with the data fiduciary, then you can use that to establish relationship, age, identity. Otherwise, you've got to fall back on certain other measures that the government has identified. So again, like, what do you make of this? We've been having conversations with some of our clients again on verifiable parental consent. So anything that we want to flag for the larger group in terms of consent? Yeah.
Sure. Maybe we can start with consent managers and
Sure.
and maybe
Sure.
close that piece. Yeah, I think like you said, the rules now set out some more details of what the consent manager role is likely to look like, who can and can't be a consent manager. There are some net worth requirements. Importantly, avoiding conflict of interest with the data with the data fiduciaries, being data blind, which is very similar to the account aggregator framework, that you can't actually read the data or the contents, maintain record of consents, and so on. So for companies that are exploring becoming consent managers, there's some more information to evaluate, but I still think need to think about kind of revenue monetization. What does it exactly mean? Does it mean we onboard with the different data fiduciaries, and at the same time we're in a fiduciary capacity towards individuals? I think another question that's been coming to us in this context is whether integration with consent managers will be mandatory. I don't think I'm reading it that way at the moment, just based on the text of the law, that while the act does say the individual can give, manage, review, withdraw consent through the consent manager or the organization, but if the organization has already built out its own consent layers and processes, I'm not reading this currently, at least, to mean that integration is mandatory. But I'll pause to see if you have a different thought here, or or anything to add on consent managers. I also understand it kind of builds on the frameworks we're already seeing.
Yeah, no, I think I broadly agree. I feel like we're going to I'm curious to see how this sort of plays out in terms of viable business models, viable monetization models, because I feel like there's also the requirement to act in a fiduciary capacity, right? They're not data fiduciaries, but you've got to act in a fiduciary capacity when it comes to the individual whose data you're processing, which I feel like even in law generally is not an easy bar. I feel like it's a word that's been very thoughtfully put there, which carries a lot of sort of import, right? And I do imagine some amount of rejigging of the pipes, as they say, if we're supposed to roll this out at scale. I feel like again, the rollout was done very intentionally and mindfully in regulated sectors, because again, it's a little bit more controlled audience. You're directly sort of accountable and reportable, to a regulator. Here I'm actually really curious to see how a lot of this will play out. But yeah.
Yeah, and I think on verifiable parental consent, I think we expected this to be a tricky piece, and it is. I think the law simply says, I mean, not simply, but yeah, the rules now say before processing children's data. I guess two levels of questions and remarks there. One is because it says before processing, you have to ensure you have appropriate measures in place to get parents' consent. Does that mean that you must age gate in any case? Or does it mean you must get parental consent when you know you're dealing with a child? And if we read it to mean you are age gating for all, can you simply have an age gate like a self declaration which says I'm above 18 years of age? And if the person actually doesn't puts in a date of birth or puts in their age as below 18, then you say, hey, stop, get your parents' consent. Does that suffice, or could it be a neutral age gate, which is I know in the US the FTC to certain companies had asked them to implement a neutral age gate versus a self declaration. It can't be that you're kind of telling the individual you can't proceed if you're below 13. It should be a question like how old are you, and if one enters below 18, then the platform knows without indicating whether you can move ahead or not. And if you're below 18, then the platform says, hey, buddy, stop, get your parents' consent. Here's the flow for that. So, seeing a lot of discussion and different views on whether this means there has to be some more sophisticated age gate mechanism across the board for all platforms. And I think the more pragmatic approach here will be, because the rules use phrases like appropriate, technical, and organizational measures. You see what is appropriate to the service, you see the nature of service, typically what is your user base, are you directed at children, do you have an already existing large user base of children, potential harm, risks to children as well, and decide what kind of age gate would work best, whether it's a self-declaration or a neutral age gate or something more sophisticated. I know the minister and the IT secretary also have made remarks on age tokens. I think that's something that's being considered, by the government on how to build on existing infra, to build these age tokens, which will account for sort of data minimization, where the platform doesn't have to collect the identity details, but only get a yes or no on whether this person is 18 or above, or building on top of state family IDs. Perhaps, of course, that's not been built out to a to at scale, but I think these are pieces that they're thinking through. The first layer was, of course, the age gate itself, and the second was what is the form of parental consent. Like you said, I think if the parent is an existing user of the platform, the rules say you rely on reliable details of identity and age with the platform. So it could be already what information they have about the parent. At some point, if I've entered my details and my child gives my email ID there, the platform already knows me in some way, and knows my activity, can gauge whether I'm actually an adult or not through that activity, and then proceed. But the second piece, which is, it looks like if you're a new user, then it says voluntarily, you ask them to provide government IDs or rely on these age tokens by government authorized entities, which I think is something that will be built either through industry or through government authorized entities.
So are we then, so a couple of follow-ups, right? Are we leaning towards taking a little bit more of a pragmatic reading that says, you know, you first see whether or not, like, basically, we're not looking at taking the view that says age gate the entire internet, basically. Perhaps some kind of self declaration by the child, or is there any other way, is there anything else? I imagine, see, there are two kinds of platforms, right? One, of course, is, say, a social media company, for example, where you can reasonably expect that you will have children who are going to be your users, especially teenagers, right? Because everybody below the age of 18 anyway is considered to be a child. Or you've got folks at the other end of the spectrum, maybe like, us, where we're not really expecting folks to be accessing a law firm's website unless they're 18 and up. What happens to this vast gray that exists in the middle, right? You could be a newspaper, you could be a shopping website, you could be an e-commerce platform, you could be a food delivery app. I feel like the challenge is really in the gray. So are we seeing companies or businesses preferring to err more on the side of let me just over comply? Because in some ways does that open up its own Pandora's box? I read one criticism that said that if one of the purposes of this act is data minimization, or you want to limit the amount of information you're collecting, in the process of age verification or verifiable parental consent, what you're effectively doing is asking people, or in some way, shape, or form, collecting more information than is necessary. So that's one. And second is, there's this interesting phrase that they've used in the rules where they say shall observe due diligence for checking that the individual identifying herself as the parent, etc., etc., etc. And we've not seen any guidance on this, right? We've not seen what due diligence means. We don't know. Again, is there something similar that we've seen in laws in other parts of the world? And what is a company really? How do you demonstrate? What do you do if you say due diligence?
Mm. Yeah, so I think the examples that we have, there is a lot of work being done on age appropriate platforms, design, US, EU, and other regions on what might be reasonable ways of getting parental consent. It could be you ask for a credit card on file, so you know that it's only an adult who's involved in the access to the platform. It could be behavioral data as well. There were some platforms that might ask for responding to some questions, depending on what is kind of the what sort of platform they are. Some questions to determine whether the person is likely to be a child or not. More sophisticated in some cases, depending on the risk of harm, it could be um, government IDs as well. Although that does raise questions around data minimization, because a platform like ours, of course, we do not want to. It's just simply a website. It's like an edge case. We don't necessarily want to institute or have more information than it's really not required for us. I think for this category of websites and platforms, I wouldn't necessarily read this to mean that we must also have some sophisticated age gate, or we must also have some mechanism to actually take in more and more information. An age gate could perhaps be read as a self-declaration, where in our terms, or some disclaimer when one is on the website, you simply confirm whether you're above a certain age or not. But of course, where you already have evidence that there is a significant proportion of your user base which is children, perhaps slightly more sophisticated methods may need to be used. There's some research ongoing around the world with tokens, whether you can also rely on third party service providers who may be able to, who have some kind of a repository. Let's say the individual has some kind of an account there, and then they only tell you yes or no, similar to OAuth, like social login, where this is a third party service provider which can help just tell you whether this person is above or below a certain age criteria. I think in India we may end up seeing more examples of this build out, likely building on our public infra, because that seems to be the sort of the what the government's also been hinting at for some time.
So here's an interesting question, right? And perhaps this feeds into some of the data sharing, or even the kind of infra that we may see out, or the kind of solutions that we might see some of the large tech companies offer. This comes from Amol in the chat. In case of verifiable parental consent, if the parent does not have an account on the same data fiduciary which the child is trying to access, but another data fiduciary, can the first one ping the second one to enable the parent to provide consent, or do both accounts need to be on the same data fiduciary? I'm leaning towards the view that both need to be on the same one, but is there any scenario in which the first one is possible? Right? As a data fiduciary, can I reach out to 5 different companies and say, hey, do you have any information about this person that will help me establish this and get verifiable parental consent?
That's an interesting way to approach this. I think that's what like third party service providers would mean. I'm not sure if the text of the law currently supports that,
Supports
because it
that
says
reading?
reliable details of identity and age available with the data fiduciary. Um, the second piece does, because but that would only be if the government authorizes that entity in some form, or provides some kind of guidance around what those tokens might look like. But I think this is like a third party service provider almost, where you're able to ping somebody and the third party can then just tell you yes or no. I'm not sure if we can read that as data available with the data fiduciary in the current text.
Got it. Got it. There's another question. I mean, like just in terms of practicality, right? Again, this is something that Anurag has asked, and maybe if we just want to expand this to what are we seeing businesses currently do? He's asked whether OTP, phone number based OTP verification will suffice, which is basically widely used by social media companies, given that the phone number would typically be, sort of issued to issued to adults. There are also open questions again around what happens if parents and children are using, multiple people are using shared devices, folks are not around to give consent. What happens in a lot of those cases. So yeah, I mean, OTP or anything else that we're seeing emerge already, anything else that companies are trying from a market uh, practice point of view as well.
Mm-hmm. Yeah, I think again it's divided into the kind of services and the kind of company you are, where you're placed. I think overwhelmingly we don't see anything more sophisticated than OTP verification for a large number of platforms, or base like a neutral age gate, or you put in your age and that's it. Some platforms may not be accessible to people below a certain age. If you're truthful, of course, if assuming that the child is truthful when
Yeah,
they
I
put
feel
in.
like that's a given though, right? I feel like that's a is that a handicap that we have to accept? Because one of the things that we've read is like, but children could lie and children could pretend to be their parents, and even if you say insert credit card details, how hard is it for a 16-year-old to get hold of their parents' credit
Mhm.
card? Or just the cell phone is just lying around, or if it's just one cell phone being used by the family anyway. So I feel like if you wanted to, you could find, like, nothing is going to be perfect. So is that something that we've just agreed to live with and say best of our abilities? And does the law recognize this? Like,
Yeah, yeah. Perhaps the phrasing appropriate measures. At some point, you have to draw a line. I don't know how much one can, unless we go slightly extreme with kind of age gate and build that kind of mechanism, or public infra rather build on that. But that might be excessive. Just is it possible to do? Even that can be gamed by smart kids, and of course the law is also, it says 18, so it's sufficiently young adults. There are ways to game the system for sure. So I think some level of reasonableness we'll have to live with here, but some best efforts, at least on the part of the company. I think just based on usage as well, if there is a way to determine, or let's say if the first instance the user puts in their actual age,
hmm,
and then they realize they can't move ahead unless they get their parents' consent on the same page. If they're trying to go back and then change or edit their age, I think the platform may be able to identify that it's kind of the same user from the same device in the same next minute.
hmm,
So I think in those cases it would be okay to ask for additional review or ask for additional information. So some kind of a best efforts judgment, I think. And I do think while not crystal clear with the language, I'd be more, I mean, I'd read it as reading it into appropriate measures, and also the fact that it talks about due diligence, that the parent is an adult.
got it. And you mentioned behavioral tracking, right? So one of the things, obviously there is a bar generally on tracking and monitoring, and there's a bunch of sort of exceptions that the rules now recognize. You're allowed to do tracking and monitoring in certain circumstances, and this specific one to ensure that you're collecting verifiable parental consent is a recognized exception
Correct,
to that
correct,
bar.
correct.
Right.
Correct. Perhaps for these kind of scenarios where you're able to track and identify that it's a child, and access we need further information before we can allow the individual to proceed.
Got it. And are we, so again, one of the questions that has come up is I just want to be clear on this, right? You need to get parental consent in India no matter what. There's no, or are there certain scenarios in which, legitimate uses or any other kind of scenario in which I, as a platform, can process the personal data of a child without parental consent? Does our law imagine that kind of scenario existing? That is one. And related to that is, of course, the question of, we just scratched the surface on this a little bit, is this question of tracking, monitoring, and targeted ads, right? So, as far as I understand it, in Indian law, need parental consent to process personal data of a child. Parental consent should be verifiable. Um, in certain, there is a general bar on tracking, monitoring, and targeted advertisements. And the rules have made some kind of an exception for tracking and monitoring.
Yeah, yeah. So on your first question on can you process for other legitimate uses? So I think that same clause which we were just speaking of, that exception which says if you
Yeah.
need to confirm whether the person is a child or not, there are some other exceptions also provided there for parental consent, which is if the government is providing a subsidy or a benefit, which is one of the
So,
recognized legitimate uses, then that's fair game. If someone's performing a function or a duty under law, if it's like a legal obligation and you're collecting a child's data there, I think that is also an exception. Of course, if you're investigating a crime, all of those law enforcement, I think those use cases would not require parental consent, and even the bar on tracking and monitoring would not apply in those instances. And just on that bar on tracking, like you said, like there's a kind of a hard bar in the act on tracking, monitoring, behavioral monitoring, and targeted ads which are directed at children. And the exceptions are only for clinical establishments, for educational institutions, some allied services. And I think it'll be interesting to see, the scope also of educational
I was
institutions.
just
Of
about
course,
to ask, because I know internally we're a house divided as to whether some, at least on two, how formal, for lack of a better word, does an educational institution does it need to be? Is it just schools, colleges, universities as recognized by an act of parliament, state legislature, etc.? Or can we expand it to think about edtech platforms? Can we expand it to think about, coaching centers? Can we expand it to think about, any platform where you can have a MOOC? So just what, right? Even edtech is not a unified bucket. Like, there are many ways, shapes, and forms in which you could have an edtech platform. It could be a offline first, but also has an online presence kind of organization. So just, yeah, I mean, what is your take on this? I know that internally we've gone back and forth on this a little bit, but yeah.
yeah, yeah. No, so I mean, the educational institutions are defined as institutions of learning that are imparting education. I'd read these widely only because the bar is also then extreme. Especially for and it's also just the bar is only removed to the extent that you are doing any tracking, monitoring for educational activities or in the safety of children. So let's say it's curated course that you're providing to a child and you're able to suggest what are the other, let's say, what quizzes you must take based on your performance over the last year. This is all kind of done online. I'd argue that that's kind of essential. That's very much a core educational activity for, regardless of whether it's a school or university, or if it's a platform which is administering this kind of learning course or this kind of a developmental course. And I think the rules also do not refer back to any statute as such, or
Sure.
limit the definition to only certain kinds of institutions. It says institution of learning. Your primary business seems to be that of imparting education. And I think I'm inclined to read it that way, just because then what you're trying to do is you're enabling educational activities, or you're enabling tracking which is sort of beneficial to the child, to the student. It's not kind of for detrimental purposes. So that's how I view it, that you evaluate what the exception is for, based on I mean, just reading of the definition here.
So I want to stick with that a little bit, and I want to also look at some of these other classes that they've identified in the fourth schedule, right? If you look at the condition in the fourth schedule for educational institutions, processing is restricted to tracking and behavioral monitoring for educational activities of such institution. Similarly, I feel like if we read healthcare, if we read clinical establishment, etc., etc., right? Like, it'll be, say, literally the previous the previous sort of box, restricted to supporting implementation of any healthcare treatment and plan recommended, is restricted to the provision of healthcare services. I want to understand in practice, and maybe if we can pick up a couple of examples, if we're sticking with edtech, we can stick with edtech. What does this look like, right? Like it's restricted to for educational activities. So, can I track if I'm giving you a class online? Can I track to make sure whether you're paying attention in class or not? And we like, especially post COVID, I feel like platforms have developed really sophisticated ways in which to track user behavior online, whether or not your eyes are moving away from the camera, whether you're actually typing in an exam, if there's an exam being conducted online, whether you're typing programs that are restricting what else you can open on your screen and not. So stuff like that. And what else can I do, right? One of the things that we were discussing internally is this question of you're not allowed to do targeted advertisements. Now, what happens if it's an advertisement but it's related to the purposes of educational activities of such institutions? Say you're not doing well in math. Can I offer you a remedial class? Is that targeted advertising, or is that restricted to educational activities of such institution, for example?
Yeah, I think it's a spectrum that you'll evaluate. What I think targeted ads, there's no sort of exception there. If you're displaying advertising, it's some commercial piece, third party advertisements, you've tied up with somebody, you're showing ads. Again, these are not ads that everyone. These are targeted ads. So it's based on my behavior on the platform, or based on a child's behavior on the platform. They are being shown a certain kind of ad. I think that's a no go. That doesn't there's no the exception doesn't really extend to those scenarios. But as long as whatever you're doing, you can justify as this educational activity, which is your learning outcomes, you're curating a plan, you're showing leaderboard rankings, you're suggesting some different courses that may be relevant within the sort of bucket of the specific purpose or the specific cost that you're administering. I think all of that is fair game. It also says interests of safety of children enrolled with the institution. So perhaps even mental health screening, and well-being. If for at-risk children you want to do some screening, you want to be able to ensure that you're identifying such children who might need interventions. I think all of that one would be able to. There's some level of tracking or monitoring that one can do for those purposes.
Got it. I want to turn to part B, right? Which is again like a more broader, not limited to edtech, healthcare, clinical establishments, etc. And Amol has asked one question in the chat, which speaks to that, specifically row number 4, right? For ensuring information likely to cause any detrimental effect to the well-being of the child is not accessible to her. Now, one is, of course, the question that's come up in the chat. Does this create a positive obligation on a data fiduciary to track all information which a child is likely to access and then block it? That is one. Second is a little bit more of a, because I remember reading one criticism somewhere that said, if I'm not allowed to track and monitor, I will not be able to filter harmful content,
Yeah.
right? So one is a positive obligation to that everybody must do it to ensure that the internet is safe and secure for all children. And number two is a slightly maybe toned down reading of this. If I wanted to, if I was a social media platform, if I was a OTT, service provider, if I was various different kinds of services where it might be mixed use, right? Like it's not only children. Certain kinds of content is appropriate for children, certain kinds of content is not appropriate for children. Does this give me the sort of leeway to do that? Does this give me the leeway to, yeah, to be able to screen? Um, that's one. Maybe let's start with this because I also want to spend a little bit more time on the targeted ads
Sure,
piece as
sure.
well. Yeah.
Yeah. I'm not reading this to mean an active obligation to screen. Perhaps there are other laws that will govern that, but I am reading it like a good Samaritan sort of where you're if you're doing this, then um, the individual or one can't proceed against the platforms saying, oh, you behaviorally tracked and monitored the child. Because if it was for this purpose of weeding out kind of harmful content and making sure that they're not accessing this kind of information, I'm not reading this to mean an active obligation to screen harmful content necessarily, at least the data protection requirement here.
Got it. Got it. And just on targeted advertisements, right? We're clear that there is a bar on targeted advertising. Do we have clarity on what exactly a targeted ad means, right? And in what instances may it not be a targeted advertisement, right? Like when is it a service offering versus when is it a targeted ad?
So I think one layer of thinking about this is if it's based on the information on usage or actual behavior or profiling. If it's not based on the users, so let's say you, me, everybody is seeing the same ad of the same product or the same discount or the same voucher or that I wouldn't, that's not a targeted ad. That's not based on profiling of my data. Everyone is shown the same sort of ad, versus something which is because I made certain choices on the platform, I'm more likely to engage with the content. So that's behavioral kind of, advertising. And on whether what is a typical commercial offering, I think we fall back then to the exceptions there, which say if it is necessary for health services or if it's necessary for the educational, it's restricted for two educational purposes. It's kind of built in. If you're browsing one particular course or the parent has bought a particular course for the child, and any kind of learning outcome, anything that you're suggesting to them within the umbrella of that, I think would be fair game. But anything outside of that, I think to the child, that perhaps that's not an ad to be shown to the child. There's nothing barring us from actually, yeah, that's sort of, if there is any other content, if there are any other ads that you'd like to display to the individuals, perhaps the parents are the right folks then to communicate those, that kind of commercial communication.
And what about personalizing, right? I can't possibly personalize or I can't possibly curate um, a content feed, especially without, I imagine some amount of tracking. And for this, I mean, I feel like obviously this is a social media question, but this is also anything, right? It could be a search engine question, it could be a news website question, it could be a OTT platform question, anywhere where there is any element of personalizing. It could even be a recommendations that an e-commerce platform is offering me based on my previous purchases, right? Wherever there is an element of personalizing, which only happens over your data being studied over a period of time and insights that are being drawn from it, is that, how does that play out with respect to children? Am I allowed to do it or not?
If you know it's a child, there is no exception under which you can do that. Perhaps the only limited one being if you want to screen out harmful content. If you know what a child is clicking on and what they're seeing, you're able to block access to that content under the provision that we just discussed. But if there is no other exception that you're eligible to fall back on, you're not an educational platform, not health, and none of these apply, the government ones or the other ones, you're not creating a user account, then I'm not sure how one could use personalizing a feed based on the user's specific information or specific profile. Perhaps some level of not personalization, but some level of curation based on region,
Hmm.
or language, because some kind of auto detection you'd have to do. Let's say geolocation, you know where a user is. It's contextual, the feed, because otherwise it becomes completely irrelevant. Perhaps that sits in a gray area, and I'd lean more towards that being permissible. But hyper sort of personalization based on a specific child's usage, I'm not sure if that is permitted.
Got it. Maybe just to put a pin in this, before we move on to discussing a couple of other issues, right? Just from a forward-looking, uh, what can we ask the government for clarification, right? Is this something that you think is is this something that you think we can ask for? I'm just seeing literally as it's just come in Prasanjit's comment as well. Can it not be argued that personalized services are for the benefit of minors, especially where minors would genuinely benefit from such services?
Yeah.
Is there a catch-all? I don't think there is, right? Is there a general catch-all that says you can do any kind of monitoring if as long as it's in the interest of the child? I think it's not. I think that's also qualified. So, do you think it's merited to ask for such a, you know, I don't want to say ground, but this kind of an exception at least to tracking and monitoring at least be recognized? That is one. Second thing was that I would love to see is maybe just recognizing other ways to do verifiable parental consent, right? So if you have an account with any kind of data available to you, otherwise you can fall back to, government issued IDs, tokens, whatever it is, or even just a catch-all any other way. As long as you're with a bunch of caveats on, as long as you're being careful and so on and so forth. I mean, do you think that there's any merit in asking for clarifications or requesting the insertion of these two, and anything else that you'd like to see
Sure,
before we put a pin in verifiable parental consent and children's data?
Yeah, yeah. No, I think for beneficial use cases, so this is a bunch of beneficial use cases that are kind of hard coded in the rules, but there may be several others that we've not thought of and that are not envisaged. The Act does provide for this mechanism in another section which says, so this was a section which said, here are the rules which say which are the purposes, what are the kinds of entities that can claim an exception to that bar on tracking and monitoring. But there's another provision which says if the platform is verifiably safe, there is, you can demonstrate that the platform is verifiably safe. There may be some exceptions there. I think that's a piece to explore as well. Under the Act, the rules are silent on this, and I don't think we were expecting rules on that. The provision doesn't expressly say that, but what would be a channel? How would you communicate this to the government? Is it like an application or is it like a self-declaration? I think that might also be helpful because there could be many other use cases which we're not thinking of, and even personalization to an extent in certain circumstances may be beneficial, like some of the comments were pointing out. You don't want completely random like that doesn't help the child, neither does it help the platform. So I think that might be a piece to pursue. It's the 9(5) exception which uses the phrase verifiably safe, because you conduct some kind of you do other things to make sure that you're accounting for the safety of the children on the platform. Um, and on your question, I agree with you. I think your remark on is there room for more clarity? Because right now it looks like for existing users it's fine, but you rely on what you have. But even there, one of the comments, I think Amol's comment on, can I rely if I don't have the information? Can I
Can
rely
I rely
on
on somebody else's
third
information?
parties,
Yeah,
third
yeah.
parties information? I think that's a fair one, because while fair, I mean, all of these tokens and other mechanism may take some time to build out, and it will involve a lot of stress to those systems as well. So if there is some more flexibility in a way that can achieve the same objective, I do think that's worth engaging on as well.
Got it. Three questions. Sorry, last. I know I said we'll move on after this, but as I'm going through the chat, more are coming up. What is an educational institution, right? There's one that says e-commerce platforms being considered if they have educational articles and listing on the blog. I feel like I'm not inclined to say that. I feel like there will still be a, what is your primary purpose, right? If it's just everybody has educational content on their blog, I don't think that necessarily makes me an educational institution. Like, I'm still a law firm, but tell me if you disagree with that view. That's one. Second, there was a question in terms of that Anurag is asked, which is there any insight into what constitutes detrimental, right? I mean, there's obviously the obvious stuff as to no tobacco, alcohol, gambling, whatever. But uh, is it just something that affects children's health at a macro level, or really just any guidance, or how would we look at loud thoughts, if you have any, on what we can look at in terms of detrimental. And the third one is, again, the shared devices sort of ghost is a little bit back, right? Which is something that Mrityunjay is asking. What happens if there are shared devices and targeted advertisements are based on parents' behavior on the platform, and it's being shown to the child, and it may not be something that's necessarily in the child's interest? I'm not sure whether shared devices is something that the rules have thought about in any detail, actually. But yeah.
Yeah. And to what extent also the data protection law could address something like this. But I'd imagine in practice, like with platforms, you'd have kids' profiles. So I mean, I'd leave it up to parents then to log out once they've once they've used and have handed over that device to their children. But it's definitely a tricky one. I mean, I don't think we can oversimplify that the piece on shared devices. But can the how much can the law address it? But a lot of platforms would already have, if you're switching back from a kid's profile, or rather from a kid's profile to an adult profile, there'd be some check, some layer, some question, something to enter, OTP, or some other mechanism. Perhaps there are tech solutions to some of those problems. I'm not sure if the law can hard code one way or the other, how you'd manage shared devices. And yeah, I think your first question was on.
Who is an educational institution? And
Yeah,
incidentally, any
correct,
education
correct.
content incidental is not something that you would consider to be an education institution.
Yeah, I think some kind of a dominant, what is your purpose? We have to think about it that way. Otherwise, a lot of platforms, I mean, it might defeat the purpose of what the provision is trying to exempt, educational platforms from. So I'm aligned with you there. And on detrimental, specific to children, I think all of the things that you laid out, there is some objectionable content, even content that may be listed out as harmful or prohibited content, that kind of ensuring that a child is not able to access that. I think that's perhaps what they mean here, because it speaks of access,
Hmm.
rather than just sharing.
Got it. Okay, I want to move very quickly to, so we're at 3:58. I want to spend a little bit of time on retention and deletion, before we perhaps, and really just exercise of rights, how an individual will exercise rights when it comes to, and what that means for the business, before we before we move into the B2B segment a little bit. Basically, yeah, I mean, just any observations that you have, that you want to start off with on retention and deletion, right? Like linked to this purpose of, uh, you know, yeah, you're not allowed to keep for, you can only keep as long as the purpose is being served, basically.
Correct, correct. Yeah, that was the baseline in the law, that you only keep as long as purpose is there. And the rules add another layer, which is, I mean, it was provided for in the act, but set out those timelines, that if you are an e-commerce company, or if you're an online gaming intermediary or social media platform above, with user base above a certain threshold, then if for 3 years the user hasn't had any interaction with you, or reached out to you, or for grievances or rights, or engaged on the platform at all, you must then send them a notice letting them know that you will be deleting their data 48 hours before that 3-year timeline is elapsing, and then go ahead and actually delete the data. And I think this is sort of geared towards ensuring that, let's say I've created an account 10, 12 years back, and it's been inactive for the last decade. But so it's kind of for dormant accounts, as to don't hold on to data indefinitely. But there is this prompt that you must provide users a prompt. If I want to be able to say, no, I'm happy with retaining my account, I should have the opportunity to do that. I think there are some exceptions there, though, that if for each of these, that if you can retain some data to enable the individual to access her account, and if there are any tokens or any rewards or anything else which are associated with that account, that's fair game. You can retain that much, because that is for the benefit of the individual. But all other data looks like, from 3 years from the time that the individual last engaged, with the platform, you must go ahead and delete. Of course, you can retain information that's required for legal compliance. So if you need invoices, you need tax information for compliance with, you get a notice from the IT authorities, of course you need to retain some information to be able to demonstrate your compliance with that law. Even under this law, if you need to retain audit trails for your, let's say, consent logs themselves, verifiable parental consent you've taken, so all of those to show your compliance with the law, or to defend yourself, or to exercise your legal rights. I think there are exceptions in the law to enable retention. If you're complying with any other law, you can retain data for those purposes, disputes and other pieces. But otherwise, the idea is businesses should not be holding on to data indefinitely. And I think this definitely kind of goes back to that inventory piece that we were discussing, that you must first create those inventories. There's a recent decision in the EU also about data minimization. So I mean, the idea is that if there is any data that you identify there which you don't really need, then I mean, there's no purpose. It's not meeting or relating to any active purpose that you have, then go ahead and delete. Don't collect it also going forward. But the idea is that for dormant accounts, you kind of have this automated process for deletion.
But
And this
this
might look.
business of, sorry, go ahead, go ahead.
No, go ahead.
No, but this business of compliance with the law for like legal purposes is, I mean, do you see that giving some comfort, um, sort of comfort to you, if you were a business? And I feel like again, retention there. What does retention there look like, right? Like I know that this is also a piece that we've worked with fairly extensively on, advising companies. One obviously is different laws have their own retention thresholds. So, do we then typically just do you attempt to arrive at a common minimum baseline, or do you just say, listen, if something requires 15, something requires 20, and there is 80% overlap in the kind of data that's sought? Like, at what point how much do you sit and filter? How much do you sit and, qualify? That is one. And retention and storage is one thing, and enabling access is a whole other thing, right? So if it's a dormant account that I have not accessed in 3 years, but you need to keep that information for 10 years under X law and X purpose, uh, basically, is it the equivalent of lock it up and forget about it and don't access it until you actually need to access it for that specific purpose? It's not like I can, or because I've kept that data with me, I can actually do other things with it.
Hmm. No, I think if it's a dormant account for 3 years, nothing has happened. I think the idea is that you only keep limited information then on file. Now, while it says enable the individual to access her user account, is it? I mean, one way of reading user account is the entire profile and entire social graph associated with that profile, but I'm not sure if that's the intention. But perhaps you look at the purpose here, which is permissible, and all other data you do not retain. In practice, I think currently a lot of platforms might also be, for many purposes you do have to retain data for accounting, and the practice might be to just keep the file in its entirety. But I don't think that can continue. There has to be some segregation of, here's the data that we need from an accounting lens for certain purposes, and we retain that. This is required for legal compliance, but there may be a lot of associated data that is not really required for legal compliance. So I do think we need to do that balancing exercise. And even when we come up and arrive at retention policies for companies, it is an exercise of looking in detail at the data that you're collecting, looking in detail at the specific requirement, what you strictly need to retain, and where you don't strictly need to retain under the law, then evaluate whether there is any other benefit of retaining it. Whether, I mean, if you fall under e-com or social media or gaming, then I think the dictate is to sort of go ahead and delete, unless it's for those limited purposes that are permissible to you. And I think just on different teams might be using the same data, like employees' data. There is statutory registers that you have to preserve for a while under the Shops and Establishments Act and different legislations. You may need the same data for accounting purposes, TDS withholdings. So some level of archiving as well. But if there is any other associated information you go ahead and delete that. I think from a consumer lens, it might mean that while I have some data about the individual, so that if there's a dispute tomorrow, I'm able to actually respond to that dispute effectively. But I don't have the right to use that data for simply sending them marketing communication anymore. They're not an active user. So the purpose also definitely does matter. So typically in retention policies, you'd also have who's the owner of that function. Like if it's a copy of the data, then who's kind of managing that record for that purpose. The rest, it's kind of archived otherwise for the purposes of the organization. It's only live for those purposes.
And just one final question on this, right, which I thought was interesting. I can't consent this away, right? So there is a question that says, can the platform take a consent from the user to delete the data even if there's no activity? Apurv is asking this. That's not something that the law envisages, right?
You mean upfront let's say I'm
Yeah,
creating a user account and
yeah,
there's an upfront thing that I won't delete ever.
yeah.
I don't know if that can work because the law actually makes that assumption for you that if it's an account that's been dormant for 3 years, the individual hasn't engaged. It's kind of the law has made the choice for you. But yes, there is the requirement that you notify the individual 48 hours before deletion, and at that point, if they engage in any way, click on a link, do something, they show
Hmm.
interest in engaging, then I think
Hmm.
you can retain that data because the 3 year, then the timeline resets.
And another one, a follow-up is, and I promise I'll move on after this, is automated payments. What constitutes activity? Do you need to actively engage, or what if I've got like subscriptions, right? Automatic payments, and I've just forgotten to disable automatic payments. Is that a scenario?
Interesting,
Yeah,
interesting. I don't know if the answer is in this law, but those dark patterns guidelines also required it. RBI has its own mandate on
mandate.
autopay.
Yeah,
On you have to remind users every time. So
yeah,
this
yeah.
notification
Yeah.
has gone to the users. I don't think the data protection law changes that perspective. If you've kind of stayed active, but that's an interesting one.
Interesting one, right? Yeah, yeah. And okay, yeah. Any other final thoughts on retention? Anything that we want to see differently in the law? Anything that you think worth asking Meaty for in the revised draft of the rules?
Not as such. I think this is more a question of compliance, whether we can put in place. But I think one thing we've been mulling over is like the question that you asked on, can I, let's say it's my account has been dormant for the last 3 years, but let's say, and I forgot, I missed the email that came to me saying, or the notification that came to me saying I'm going to delete your account. But a month down the line, I realized, hey, I actually want to revive that account. Would can the platform take comfort in this, enabling the individual to access her account such that it was dormant for a little more time? But once the individual has made the choice, so just again in the interest of the individual. So perhaps it doesn't. I'm not expecting that level of granularity in the rules either. But that might be something to just ponder over.
That might be something to point out. Or maybe you start making these efforts well before the 48-hour timeline, right? Like you send more than one email to make sure that it doesn't get missed, or yeah, I don't know.
More
I don't know.
notifications, yeah.
More notifications. I don't know. I don't know what else it might look like in the current form. Because I've run this. I've gone back to social media platforms after many, many years
Yeah.
and then had to jump through several hoops to verify my identity and make sure that the account was actually mine to be able to reclaim them. But yeah,
Mm,
yeah,
mm, mm.
yeah.
Fair.
But okay, very quickly into individual rights and uh, what it takes for me to exercise my rights, right? So I feel like two things at least have stood out. One is to disclose the details of the information who contact information about the person who's going to answer questions about processing, right? Whether it's the data protection officer or whether it's somebody else. That's one. And I think data fiduciaries are also required to disclose details about their on their platform about how an individual is supposed to exercise any of the rights that are that are available to her, right? The details, how you can make a request, any other particulars, username, identifier, which may be required for identity verification. You're required to make a yeah, you're required to make all of this information that's available, uh, to the
In the
to the
notice.
individual, and you're required to make sure that it's an effective system, implement appropriate technical and organizational measures. Now, is there a specific time period, or I mean, are we basically just leaving it to companies to decide what is the time period, how long you're going to take to act on this request of an individual?
Yeah, so for grievance redressal, the idea is you have an easy mechanism for users to be able to exercise their rights. There is no time period specified as such, but you have to publish the time period for grievance or actually for your response. By when will you be able to respond? I think there could be different ways that this plays out. One is perhaps we'll end up seeing a lot more of these FAQs and self-service options also, where if it's some query, you have the option there itself. You can view the response there itself. Of course, there are certain additional things which will require them to write into the DPO or to the contact person in the organization. And some response time though the organization will have to publish. I think depending on the volume of requests, if there's a large volume that you're anticipating that you're already getting, it will be impossible to have this in a manual form. So definitely to the extent possible, one must automate. So that's why I think self-service or some automated response as well while one is evaluating. And I think very strong internal mechanisms then for the organization to be able to direct the query to the relevant team and then get a response within a reasonable time frame. SOPs and protocols internally, and sensitization, because I think currently a lot of it's kind of ad hoc often, where you see there are, of course, people can write in, there are contact us buttons already, but maybe for some organizations which don't get a lot of volume of these requests, it may be ad hoc, but just in anticipation of the just onslaught of queries that one might get, I think very important to have in place those mechanisms, and also give clear information, maybe set realistic expectations on how long a grievance might take. The rules also don't specify within how much. I think in the SPDI rules it had said 30 days you must respond. The rules don't make that choice. I think again leaving it up to the business to make that determination, but perhaps we look at these other legislations for at least some idea of a response, not just response time, but resolution time as well, for some guidance.
Or anything in other parts of the world? Is it odd that there's no resolution time prescribed, or is it common? Like, do data laws around the world or any kind of guidance that we've seen now emerge from regulators? Or because there's also I feel like, and this is the experience that we've definitely seen through the GDPR and also other parts of the world. If you don't act quickly enough, then also it's a problem. But so yeah, I
Yeah.
feel like, would you want to see something prescribed in the next
Not
iteration?
necessarily, actually, no, because it may again depend on the kind of platform. If it's a platform that there is, let's say you have to then, there's a channel internally, or it's about, let's say, blocking content or some other it related, some other user's account as well. It may be a different channel, it may take some time. Versus if it's just a simple access request, which may not necessarily, take a lot of time. It's only related to that particular individual. There's also the requirement to provide lists of data fiduciaries that you'll anyway be maintaining and retaining with you, whoever you're sharing that, data with. So there, I think that flexibility may be intentional, instead of hard coding it in the law that you must respond within, you must resolve grievances within 48 hours, leaving some flexibility there. I think that is desirable, and but at the same time, I don't think this means businesses have, an indefinite amount
A
of time
carte blanche. Yeah,
it's
yeah.
not a carte blanche either that you wait for a year and you sit on the request. I'd still think an immediate response needs to go into an individual, because there's it's you put this out clearly essentially in the notice as to here's how much time you can expect this to be resolved within, just as you would for good service delivery. I think for data grievance redressal also similar timelines you'd have to think about.
Got it. Um, Anything else that we want to flag on user rights? Otherwise, I want to breach obviously is a relevant one, and I know we said that we'll deal with sort of the housekeeping part of it in part two of this edition. But just very quickly, if we want to take 30
Yeah.
seconds, because breach also requires individuals to be notified as soon as a data fiduciary becomes aware that something has gone wrong. There is a responsibility to notify individuals also
Yeah.
fairly quickly with a list of things that you're required to tell them.
Yeah.
And I know that this has been met with some mixed responses around, breach is a wide concept. Do I have to tell you about every single thing? It's not feasible, it's not desirable, it's going to cause panic, it's going to cause breach notification fatigue, like we were talking about consent fatigue, back in the day. So yeah, just quick thoughts that we might be able to maybe pick up on in the next.
Sure, sure. Yeah, I think, like you said, I think breach is also defined as any unauthorized processing or accidental disclosure. It doesn't quantify it as big or small, or if it's like a routine, some incident which has been resolved and it has no implication on the individual. So there's been a lot of discussion on whether this reporting means everything, every incident, big or small, needs to be reported. Or let's say if it's a laptop unattended in a public place, it's a salary slip photocopy which is left in one part of the office building, what all will constitute a breach? Because we've heard of these instances happening, and companies actually having
Yeah.
to think about whether these are breaches or incidents that need to be reported. I'd still I think there's room to perhaps see clarity on this one, because just on, I think global precedent suggests that while of course you do have to you anyway have to report to CERT, you anyway do have to report to the board as well, and it's a tiered notification. You report immediately and within 72 hours provide more details. But it's desirable to have some kind of a threshold, I believe, for reporting to individuals, just for these sort of instances which are very routinely resolved and may not actually have led to any disclosure as such, just because it also says unauthorized processing. So perhaps how organizations will also read in some level of, you must first designate whether this is a breach or not. So it must still meet that criteria that are set out. It has resulted in compromising confidentiality, integrity, and availability. I think some evidence of that, because you also don't want to spook individuals when there is nothing to do and nothing to worry about. Like, I've also heard of instances where you put out a notification and then there's some investigation, and then later on the answer is nothing happened, or we
Nothing
don't know. You
happened. Yeah.
don't want to do that either. There's no real benefit to that. But yeah, I think of course, if it's an incident where I need to take some action, I need to change my passwords immediately, I need to log out of devices, then I think there is no question. One must notify individuals with what they need to do to protect themselves. So yeah.
Okay, but you hold that thought for the next one, because I feel like if we open breach, then we'll sit here and talk about breach for the next hour. And I do want to move into bucket two, which is business to business, right? Fair bit, I think, here left to organizations to figure out. I think fair amount of flexibility. Um, there are no real direct obligations on data processors. It's just contractually, and then to see, in fact, now finally some reference to contracts that fiduciaries might have with processors, right? Where you specifically need to pass on some obligations contractually, and where it will play out specifically is, say, the security safeguards that data fiduciaries are required to have in place, and also when something goes wrong, right? So when there is a breach, what do you do? Because if all of the responsibility is on the data fiduciary, then obviously you're going to pass a lot of this downstream to processors as well. And we've seen again some conversation. I don't know how you feel about this though, because I feel like this approach is at least unique to India. Maybe let's just start with that. In most other parts of the world, there's something, right? At least the obligation to have to implement technical safeguards, to implement security safeguards, or a clear call out that says um, follow the instructions of the data fiduciary or the data controller. Um, Something. I feel like, am I right in saying that we're unique in this respect, or have we seen this in other parts of the world?
Yeah, I think while, of course, the distinction fiduciary processor is the way it is everywhere else in the world, that the regulators, individuals all catch hold of the fiduciary primarily because they are their primary stakeholders often, and there are obligations that you pass downstream. But yes, I think the Indian law doesn't speak of a lot of jurisdictions at least set out what all should be included in the contract, at a minimum, perhaps. But I'd still read some of that into just based on a reading of the different provisions of the law. That I think there are some places where there's specific references, like you were saying. I think in deletion as well. Now security safeguards, a few places. But our law simply says have a contract in place. But I'd read a lot of the requirements. I think it's great for lawyers where there's more room to negotiate. It's going to be more fun for us. But I think one can still identify which are the minimum requirements that you need. We already see a lot of supplier agreements have some clauses at least. And I think this specific reference, the 7 security safeguards that are set out in the rules, they are all tempered by phrases like appropriate and reasonable, and of course logs you have to maintain for a year, all of that. But a lot of these obligations will get passed on to vendors. We already see some hard negotiation on some of these. If you're a processor, you'd want more specificity. You will not want to accept a broad I'll agree with applicable law. Anyway, the law has no obligation, so that's not helping me, but not helping either party actually. But to what level of specificity? I think processors would want the fiduciaries to tell them, give me this SOC 2 report, like very specific, I think, standards.
Maybe let's spend maybe the next 5 minutes doing that, right? So let's play out both scenarios. If I'm a data fiduciary, and I want to enter into a bunch of these contracts with my processors, what are some top 3 4 5 things that I want to what is best case scenario for me, right? Is best case scenario audit right? Is it uncapped indemnity? What is best case scenario and what is more realistic, right? Because you did say also that we do see a lot of sort of hard negotiations on this. Say, just to kick things off, one of the things is, can you have sub processors, right? And I feel like best case scenario, I mean, depending on how uh, best case scenario also start, depending on how involved you want to be. You either say, you either have a restriction on sub processing, or you say, don't appoint anybody or don't share data for downstream further without checking with me first, or
Yeah.
you maybe give a list of pre-approved sub processors or services or whatever it is that your processor can use, and anything outside of this list, they have to come and ask you, the fiduciary. Or the fourth one is, you figure it out, right? You've got the obligation. I don't care which sub processor you use. I'm going to make sure that you're the one on the hook. And likewise, back to back, back to back, back to back, this continues to flow down the chain. So yeah, I mean, what else are we seeing in when it comes to audits, maybe, or any other couple of clauses you want to talk about?
Sure, sure. So as a fiduciary, there are a few things that you'll insist on. One is that, the processor will only process the data in accordance with this agreement, will limit it to this purpose and this purpose only, will not use it or share it or disclose it for any other purpose. That's kind of integral to ensure that third party is a processor. There may be also DF to DF arrangements where it's an independent data fiduciary kind of a relationship where both parties are processing. There may be some data sharing involved, but both parties are sharing data or other processing data for independent purposes, where I think that merits a separate 1 hour on its own. So maybe I won't go into too much detail there, but identifying where you're actually responsible for the third party and where it's an independent third party and you shouldn't be responsible for them. So I guess identifying the roles, documenting them, limiting, asking the processor to limit the purpose, security measures, asking them to abide by. If there is anything specific you need, then putting that in the agreement. Breach notification related stuff. So I think we didn't spend a lot of time on breach, but you have to report to CERT within 6 hours. You have to report to the DPP twice. You have to report to the individual. So for you to be able to do all of that, you need information instantly from the processor if there is any security incident that's happening. So ensuring that happens. Audit rights as well. Now, audit rights we've seen some pushback typically from processors on how much information, is it like an open access to our premises? So you'd have some reasonable caveats there that the processor provides reasonable assistance, and at appropriate notice. There may be a time capping of audit as to how many times you can do an audit. Subcontractor, like you said, I think you laid out the 4 scenarios from the most restrictive to the most enabling. I think the most enabling may not work, that you get
And
anyone.
you do whatever.
Because the law requires the data fiduciary to then identify who all the data has been shared with. So you won't be able to meet that requirement if the subcontractor doesn't also tell you who all they're engaging with. In fact, this might be a piece where there's often a lot of discussion on tell me who your subcontractors are. Here's an approved list. If you're getting anybody else, then let me know.
Let me know.
And the subcontractor, as the vendor, may not actually want to share all of this information, or may not sometimes they may have multiple vendors for multiple different purposes. So from their end, also some inventorizing will have to be done to identify. So that's a piece. I think data deletion is a piece as well, because also there's a specific reference in the law to that you must ensure that your processors are deleting, maybe seek a written confirmation. In maybe some cases have something more stringent depending on how the agreement is, what kind of a services contract it is. So these are a few, and of course there are some standard pieces, like you must help us respond to individuals, you must help us respond to supervisory authorities, all of that. Of course, the most critical is the indemnity. You absolutely must insist on being indemnified for any breaches. From the processors end, they typically, of course, do push back, seek cap on their liability. But I think market practice tends to, for breaches, it is the fiduciaries, because there is, like you said, for security, there is no direct obligation on processors also. So fiduciaries do bear the weight of compliance there, bear the regulatory brunt. So I do expect a lot of negotiation on just liabilities for breach. Here from the processors end, like I think I was saying, you'd want more specificity in each of the clauses. You wouldn't want an open-ended clause which says you will adopt appropriate measures, while of course appropriate does take the color of the industry you're in. You look at best practice industry standard, but they'd like more specificity there. Breaches as well, some reasonable time at least, so that they can notify the individuals, sorry, the fiduciaries.
So just one final sort of question on that, and I know we're almost at time, and then feel free to just segue into that, into closing as well, right? But just this last piece on breaches, are we expecting very open-ended language when it comes to indemnity, etc.? Because while there are penalties for uh, say breaches, etc., while there is a penalty, individual compensation is a whole other animal altogether. And I remember reading interviews, and I think it was either the minister or the secretary. I feel like it was the secretary who said that, well, we're not, basically, you'll have to rely on tort law, good old tort law, if you want to get, compensation as an individual, because that's not something that the scheme of the act necessarily envisages. So now, obviously, in practical terms, just in a B2B context, that also means that, I mean, like, am I looking at uncapped indemnity? Is that realistic?
Yeah,
Yeah,
maybe
just I thought
granular.
that was interesting that he had specifically flagged tort laws.
Interesting.
So
Interesting. Yeah.
yeah, yeah.
Maybe we'd see more detailed indemnity clauses. I think we already do see them to some extent where there are specific line items like breach of IP, breach of confidentiality is generic, but data breaches as well. Perhaps more specific indemnity clauses where in some instances maybe you agree to some capping of the liability, but actually all of the things that I've named, typically those are uncapped liability instances where fiduciaries would insist on those, but perhaps more granular indemnity clauses and some breaking up of those components also as to what you'd negotiate with the processors.
Any last words on anything here that we want to see, right? Recommendations to the ministry. Do we want to make, do we want specificity? Do we want, I don't know, standard contracts? Do we want any guidance from the government on what should go into a fiduciary processor contract? What should go into a fiduciary contract? I know that they've left, I mean, they have also said, I think Minister said this in several interviews, that, more rules will come and they'll keep evolving and this is dynamic, and we've kept it sort of, light because we want to also get this started. I mean, yeah,
Yeah.
personal opinion. Do
Yeah.
we want any more clarification? And then over to you for the last word. Yeah.
Sure. I think what might be helpful, whether it comes not necessarily from the government, but I think something along the lines of those, codes of practice, some industry guidance that develops. We do expect a lot of these agreements to also, DPAs to become a bit templatized. It's going to be like these clauses we already see there. I mean, of course, there is negotiation on whether you're fiduciary processor or indemnity, but a lot of this will become. So I think, and this will be unique, like for different sectors, this might look a little different. So I think some industry-led efforts also might help here on what typically are the clauses in DPAs. We've also seen like RBI come up with this guidance on what are the minimum things that one must include in an outsourcing agreement. And, a lot of this is kind of thought from there because we already have one standard. Of course, that is a lot more sometimes acute because there are certain hard restrictions. So maybe that kind of, guidance as well. But I think here's room for industry-led initiatives
Efforts.
for these
Yeah.
model
Or to be
clauses.
adopted. I feel
Yeah,
like Singapore is a good place to look at for this kind of stuff, right? A bunch of these
true.
practical guidebooks that they keep coming out with on a bunch of different issues. So, and very often, from what we understand, also industry led and at least participative. So, yeah.
Yes, definitely, definitely. I think there's room for in a lot of other instances also, like even verifiable parental consent, what are the different kinds of mechanisms, like and where there's some consensus, that's always I think helpful. Yeah, that's it, Neha. I think we are also just a couple of minutes over time, so I'm happy to close. I think we've covered some ground with the B2C component and the B2B pieces that we wanted to discuss. Of course, there's a lot more to do with the pieces on how do you get your house in order. I think that's a whole major discussion, and also the government pieces with localization and calling for information and what you need to do to be prepared for those. I'll hand back the last word to you.
Wow, I feel like we're playing table tennis on the last word, but no, nothing to add. Thank you for joining in, everybody. We'll do part two sometime in the coming week or early the week after that. We will be sharing details on our LinkedIn channel. So if the remaining two buckets are something of interest, please do register and please do join in. I hope we've been able to answer as many questions as possible. I know there were a bunch that were coming in on chat. Feel free to reach out to us on our social media platforms as well. In case there are other questions that you have, feel free to connect with us on LinkedIn, and we'd be happy to take them up as well. If there's something that other than this that you want to discuss, Pallavi, if I may request you to just put a bunch of our email IDs also in the chat in case folks want to reach out. They can feel free to reach out. Thank you so much, and thank you, Sreenidhi. I've really enjoyed this conversation, and I look forward to the next one that we do.
Thank you. Thanks, Neha. Thanks, everyone. See you. See you next time. Bye.